Hello, everyone, and welcome to 4IP Council's webinar From Idea to Profit. My name is Claudia Tapia, President of 4IP Council, and I will be your host today. As you may know already, 4IP Council is a non-profit research council developing high-quality academic insight and empirical evidence on topics related to intellectual property and innovation. At 4AP website, we have created an SME corner, which aims to provide relevant information to those who would like to have a better understanding of IP. I would like to encourage those of you who have not done so to click in Stay Informed on the right side of the page to be able to receive our newsletters and invites for future webinars. On 4AP Council's website, you will also be able to find information about the different kinds of IP, what they protect, how long is the protection, etc. You can also learn about how to use your IP to grow your business and much more, some of which you will hear on today's webinar. We will upload the webinar recording and the slides free of charge following the presentation. But before I introduce us as speaker today, I would like to take a moment to share the date of our next webinar for SMEs. On November 21st, Dr. Christian Schneider will be talking about intellectual property from the standpoint of a venture capitalist. Stay tuned to our mailings and website for registration details. Please allow me to introduce you to our great speaker, Begoña Otero. Begoña is a Spanish lawyer and currently senior researcher at Max Planck Institute for Innovation and Competition in Munich. Previously, she has worked as an independent consultant for European projects, international associations, and companies. She's also former dean of EU Business School, and before writing her PhD, she worked as an IP lawyer both in Spain and in Germany. With experience in legal strategy consulting, higher education accreditation, partnerships, negotiation, and change management, she's a dynamic communicator and strategic thinker. We are very fortunate to have her with us today. Without further delay, Begoña, the floor is yours.
Thank you, Claudia. Thank you very much for your kind presentation, and welcome everybody to this webinar where we're going to be talking about IP and what to do with that thing that we call intellectual property from a business perspective. So as you can see here, my plan for today, for the next 30 minutes, is to first go briefly and from a more pragmatic position on what are the main types of intellectual property rights. Then I would like to address some common mistakes that I have seen coming from startups and SMEs and business people who have great ideas, but they don't need to have a legal understanding. And we're going to see how to fix those mistakes. And then to close up, some best practice tips on how to approach that. So in order to actually try to leverage that idea and how to find the better strategy for that from an IP perspective. So many of you will know already that when we look at intellectual property, we're talking like two different parts of, let's say, I always think about an onion, but here, even if you look at a car, there are multiple parts of that car that doesn't mean that they are actually, but that they are suitable of different types of IP protection. If we think about the software, nowadays all the cars are big computer, made of big computer programs or computer engines. that can be protected under copyright, but the same happens with the design of the model of the car. Then many other parts, like the know-how or other tech systems and algorithms, can be protected under trade secret. At the same time, the same design model that we have under copyright can also be protected under design, but also other shapes and that are visual, like the keys, like the frontal of the car, even like the wheels groove, can be protected with design. And then we have probably the two that are the most famous, trademarks and patents. When it comes to patents, so like the design of the car frame, features of the brakes, or even the structure of the engine could be suitable for patent protection. And when we think about trademarks, normally we talk about brand. So the model name of the car, even the sound of the engine in some cases, the logo can be protected on the trademark. And then we have what you can see on the right of your screen, which is the domain name. And that's separated because although many might think that that's also an IP right, it's not. But it's normally within this frame or this setting of IPs. And we will see further today what exactly a domain name is. And of course, from a commercial point of view, it's super important because it's your ID when you're going into the internet. So having said that, the next question is, okay, I have all that. I have all those possibilities. I might not be a car manufacturer, but I have something else. And what is that IP can do for me as a business person? So normally we can differentiate 4 main points when we're talking about that. First, it's exclusivity. Those intellectual property rights are a property and are based on exclusivity, meaning that you will be given a certain space where you can develop your own business idea, where you can exclude competitors, meaning that you can also be the first to market, which is important when you think about how to recoup the investments that you will have to make in order to develop your own idea. At the same time, having an IP portfolio, even if it's a small, can be a good tool to attract investment, especially when we're looking to grants or even to subsidiaries, or even if we go beyond to business angels or venture capital. It's very important that your IP is in place. And third, also as an enhancer. So when we think about a brand, when we think about reputation, normally we think about trademarks and names and logos. But nowadays, that's not the only thing that really matters when we're talking about, or when we think about reputation enhancing from a business perspective. If you look around, if you look at the market, many of the companies that we have, that we know, like, I don't know, in telecommunications, we can think about Ericsson. When we think about that, we think about a company that is very innovative. So that's what gives you the reputation. That's the fact that they are very active in a field and that they are trying to do more and more. And that's also based on a big portfolio of patents. So patents and copyright, even so, for instance, when you think about Disney, so it's a name that it does not only come with a trademark, so also creativity, it's important here. And last but not least, of course, trade, because that's the main reason. And in that regard, it's super important to think about freedom to operate. So the less problems that you may find to operate in the market, but at the same time to be able to license your own products and know what you can license from others. Same happens when we're talking about negotiations and how to handle them and your position. And at the same time, also that can bring you to joint ventures, to other partnering opportunities. So there are a lot of, I think there is a lot of interest for any people or any person who is willing to develop a business idea to consider IP on how to protect it and what to do with it from the very beginning. Having said that, let's start briefly on what are we talking about when we're relating or when we're mentioning copyrights. So when we're talking about copyrights, we're normally referring to works. And I know that this might sound very legalese because work, it's anything, or it can be anything. But from a legal standpoint, a work under copyright means that it's an original intellectual creation. Examples of those can be music, can be movies, but also databases, software, architecture, etc. And what the right is going to grant you, the exclusive right of copyright, it's to have control over different parts, over different actions of what you can do with that work. So you can control the distribution, you can control the reproduction, you can control the modification, the performance, the display, etc. And it's a right that it's granted without registration and for a long period of time. So the lifetime of the author plus an average of 50 to 70 years after death, depending, of course, of the country. And having said that, I think what it's important to also remember here is that we're talking about that ability to control, meaning that you can be inclusive or you can be exclusive. So that's what the intellectual property right is going to give you, the possibility to decide how to use your right. When we're talking about trademarks, we're talking about something different. In this case, registration, it's necessary because we're talking about a right that is granted by an authority that it's going to allow you to prevent the unauthorized use of a particular sign. So we're talking about signs. Again, this is a bit, or might sound a bit legalese, because a distinctive sign that identifies a product or a service can be many, many things. But that's also what the spirit of the law tries to embrace. So we're not only talking about personal names or words or letters or designs of numbers. We're also talking about the packaging of goods. We're also talking about 3D shapes. We're also talking about sounds. We're also even talking about smells if they meet this distinctiveness requirement, shapes, etc. In this case, there are different routes, a national route, an international route that it's going to also bring you about to the national route, but it will speed up the process. And then we also have in the European Union, something that is very peculiar and unique in the world, which is the EU trademark, which is one right that it's granted over 28 countries. So the general rule is that you have one trademark and the scope, so the place where that trademark is going to be working or going to expand its power or its effects, it's the country. But when we're talking about an EU trademark, we're talking about one single registration that is going to cover the scope of 28 national countries. Probably many of you have seen these signs that R or the TM. I think it's also important, just as a remark, that the use of those signs is not mandatory. You don't have to do it, but it might be a good thing to do just to dissuade offenders, because that's one of the other things that we're going to be talking later on, and it's to consider enforcement of your rights. Having said this, let's move to the next, which is the other big, let's say, brother, which are the patents. Patents, it's one of the biggest rights when it comes to IP. But the reason is because from an investment point of view, normally it requires a lot of investment, and not just to get the invention ready, so from a research and development, but also because of the process. It's also a sign that innovation in this regard, its place around this idea of patentability. So, as I said, here we're talking about an invention. Invention, it's something that is, again, a legalese term that refers to something, a product or a process, something that it's new, that it's innovative in the sense that it does something or solves a technical problem in a way that it's hasn't been seen compared to what it's in the prior art, so in the state of the art up to now, by an expert. What you can do with a patent, similar to a trademark, but beyond, far beyond that, is that it's not just to prevent the unauthorized use, but it's also the making, the selling, the distribution of the patented invention. So the amount of control, it's greater. Again, like in the case of trademarks, we're talking about a right that needs to be registered and that needs to be also examined. In this case, again, we have 3 routes. So the national route, which is the common one, and then the PCT will be the international route. But as in the case of international trademarks, it's a formal route that will allow you to go faster, but then each of the application will go to each of the countries where it will undertake the examination and review of the patent application. And then in the third place, we have the EPO, which is the European Patent Office. And in this case, we're talking about European patents. The process is a bit of a hybrid. So it's not a EU trademark in the sense that it's not one patent that covers all the members of the European Union, but the quality of the examination here, it's really high because you only go through one examination. So one patent application, one full examination, and then if the patent is granted, if it's approved, it will become as many national patents as countries you have marked in the original patent application. The cost of applying for a patent, it's relatively medium to high. We're talking maybe on an average for starters of 6,000 euros. And the length, it might be between 3 to 5 years. So just to get an idea. And then we have the signs. The signs, they don't relate to innovation in the sense of patents, but they do relate to new and original appearance, which is also important in the market. If something is much more appealable or attractive, and it's original because it hasn't been seen before, then in the case it doesn't solve a technical problem, then it's not a matter of patent law, but it's something that it's also in an innovation. And that's what designs are about. So we're talking about the front of the cards, even the shape of a pen, a key, general user interfaces. That's now in the IoT era, that's a field where design it's playing a really, really important role, and where we're seeing things that are super innovative. But as I said, they don't solve a technical problem, but they bring a new and original visual appearance to a product, or in this case, when we're talking about general user interfaces, sometimes even a product that is linked to a service. So why is this important? Because if you register this kind of designs, then you can get protection that goes up to 25 years, through which you can prevent the unauthorized use of other designs that are similar visually or that over the same kind of products. And I'm saying that it's important to register because there is also the possibility of having protection for designs that are not registered. But this kind of protection in Europe is very, very limited, and not just in time, but in scope, meaning what you can do with that. You can have a design that is not registered, but it's only going to be protected under unauthorized copying, so cloning, more likely. And it's only going to last for 3 years. So again, I think in this case, it's important to consider designs as an important intellectual property right, especially in the connected data era that we're living in. And then, last but not least, as we talked before, trade secrets. So trade secrets, We're talking about information here, business information that is kept secret, and that means that you are putting some kind of measures to make sure that that happens. Normally, we're talking about products and processes where reverse engineering might be difficult, like algorithms, like certain financial information, like know-how. There is no registration here, of course, that will make no sense. But at the same time, it's also important to bear in mind that the protection of a trade secret lasts as long as the secret is not revealed. And when that happens, then the part of the enforcement, so what you can do in order to enforce or in order to try to get a compensation because somebody has unlawfully disclosed that trade secret can become a bit of a nightmare. It's not as easy as it looks. So on the one hand, it's important to consider this IP protection, very important, especially for those products and processes that you don't want to disclose and where reverse engineering, as I said, is difficult. But at the same time, what also needs to consider what might happen in case of needing to go to court to enforce an unlawful disclosure and to get compensation for that. And when it comes to IP, those are mainly them. I mean, there are other smallers that we're not going to talk about today because we don't have the time. I mean, just to give you an example, what happened with enforcement of trade secrets. I mean, this is still ongoing. This former Google engineer that then moved to Uber, and it's still ongoing. It's a big deal. So that's what I'm saying. But I want to talk about domain names. And I want to talk about domain names because everybody who wants to go into the e-commerce or to be visible nowadays needs to go on the internet. And that's our passport. So that's important to understand that it's not an intellectual property right, but kind of human-friendly form of internet address, like your passport on the web. Meaning that instead of having a number display on the web, it will be easier or it's more friendly to have a name like the one you see below. What I'm saying this here because, well, sometimes they get confused with trademarks, and there is a certain relation with trademarks because normally where you're going to try to register under your domain name is also most of the times the name of your company that you might want to register also as a trademark if it's distinctive enough, or another logo, or I mean the name of a product or something that makes you very distinctive. So I think it's interesting to see that when we're talking about domain names, there is no priority when in terms of registration, because here it's first to come, first to serve. They run worldwide, while trademarks have territorial scope. But careful with that. Sometimes domain names, when we have country codes like .de or .es or .pt, they might be run by national authorities. So in principle, there is no examination for .com, but they might be, or there is actually examination for .eu or .de or .es. So careful with that. And why I'm saying that and talking about territoriality, it's because this is one of the first mistaken approaches to intellectual property rights. What happened, or what has happened in my experience, is that many people come to you with this kind of question or this kind of statement, but I have a trademark for my product, and now I went to a different country and now I have a problem, or I have a patent. The first thing that we need to have clear in our heads is that intellectual property rights are property rights, and property, it's territorial. So the laws are national, meaning that the effects displayed by these rights are national. And although when we're talking about requirements for registration, in the case of trademarks, or in the case of patents, even in the case of designs, the requirements worldwide are very, very similar because there has been a lot of harmonization at an international level. We have different international agreements starting from copyrights with the Berne Convention and going to TRIPS or the Madrid Protocol or even the EPO. But then each country has its own particularities. So that's very important to bear in mind. Territoriality. And the next, it's an example, for instance, because I have not mentioned copyright, but on this regard, but that already happens. That happens too. It could be like a sign like the one that you can see on the screen, where there is a very well-known trademark, legal, and you can see below, you can read that this might look like a kind of joke, like a kind of parody. But the funny fact is that depending on which country this takes place or this happens, the approach to what parody means, it's different, or it might not even exist. For instance, in the UK or in Ireland, there is no limitation or exception in copyright to say, oh, but this is a parody, so I can do it. There is no harm here. But in other countries, the exception exists. And even in those countries where the exception exists, for instance, the approach can be different. In France, it's typified, meaning that the definition of what a parody is defined in the law, but in Germany it's not. It has been defined by the courts. So again, this is a reminder that territoriality is important and that, as I said before, each country has its own particularities. The other mistake that I have seen more often, especially when you're starting a business, and because you're going to go and get help and get to be known, is that there is a kind of confusion between protecting our idea or your idea against disclosure with protecting that idea against infringement. So the problem is that sometimes we disclose information without enough precaution. So it has happened that we don't know that if we disclose information about our new invention or our new business idea, in a particular context, we can't already have lost a valid patent later. Or that since ideas are free as free air, somebody else's appropriates that idea, and then that will be a loss for you because you will need to go into probably a legal mambo-jambo to try to demonstrate that that person unlawfully appropriates your idea. On the other hand, one needs to be careful because, well, if we are too obsessed about secretism, that's not going to be positive. That's not going to work out very well in any business strategy. And if anyone approaches you requiring a payment to reveal any detail of your new business idea, I think that's something that might have worked in the past, maybe. I cannot say that I'm aware of that, but it doesn't work nowadays. So those are things that should be avoided. However, some tips on what to do. So if we're thinking about having a private meeting where you're going to talk with potential investors or collaborators, you should consider preparing non-disclosure agreements or a memorandum of understanding, either or both. And what it's also important is that you make sure that the attendants sign the non-disclosure agreement, and whatever you're going to say about that business idea or that idea that you have, instead of going straight to the novelty, to the new thing that your thing does, it's a bit of say more about the about. So you also make sure that you don't say too much, you don't disclose too much. When we're thinking about public events, like a contest, like a fair trade, like a media or advertising, the best advice in that sense is to have secure your IP beforehand. So I know that sometimes we want to go to the media and we're going to put it out there or just to advertise it because then that will attract investors. But the moment that the investors arrive or come, based on this call. If there is no IP security, if there is no IP portfolio, they will fly away. So that's not interesting. And something that I have also seen in a couple of cases, it's what happened with the student projects, because most of the startups that we've seen, most of them are forged at universities. And what has happened many times is that you have a great student project or a master thesis or something where what happens is that sometimes the lecturer, it's not aware of IP rights, and they don't need to be. So they might not take this kind of things into consideration, and you will just want to go into public exhibition or public dissemination. Take one step back. That will be my advice. Speak with the tech unit or the technological transfer or the IP unit of the university or of the institution before going into public exhibition, if you think that in that studio project there is a business idea that might work out later. And third, and we're getting to the end, one of the other things that I have also seen is that we are so, startups are, so found on just going ahead with the business that normally they are made of individuals that they don't have any formal business structure in place. And you start working and moving and doing things, and it happens that one creates a logo, the other comes with an idea for this and something that might go into a patent or something that it's copyright protectable, and then what to do with that. So my advice will be that if then you're moving into a more formal structure, into any kind of company, consider to prepare a founders agreement or a pre-incorporation agreement, depends, the name might differ depending on the country, where you are transferring all those potential IP rights that you have separately to the company. And that way, you will avoid a lot of problems in the future. And if you already have people who are working for you or third-party contributors, you also should be careful with that. When it comes to employment contracts, make sure that you include an IP assignment clause in the employment contract. And when we're talking about third-party contributors, like a designer that you're hiring for doing something in particular, or an editor or a copywriter, make also sure that the IP is transferred, that the IP that you intend to use is transferred to your business. And then, of course, what I think it's one of the most important things when we reach this point is how to include IP in your business plan. IP needs to be included in your business plan. It cannot be left apart. And on this regard, there are two things to consider. First, at the strategy level, you should consider creation. So what do you have? What assets do you have? How can they be protected if they are going to be protected? How are you going to exploit them once you have them protected under copyright or not? What are the risks of protecting them or not? So you might decide that you want to apply for a patent, but later on, because there are many risks, or you don't have the money, you don't want to. So you also need to consider what to do to avoid others from getting a patent from your own idea. And what I think is one of the most important things when you're looking at IP is to consider enforcement. What's going to happen? What are you able to do? Or what are you what are you willing to do? If somebody else's, if a competitor or non-competitor, somebody else's infringes your rights. And on the portfolio side, things that you should consider, it's also to have a mapping. So to go across whatever kind of business you might have, from biotechs to informatics to design, fashion, etc., and to create a kind of mind map and check what are we protecting, what not, how are we, and where. Ownership, agreements, and registration and status are key, the three of them, important parts of your portfolio, because that's also what banks, what potential investors are going to also look. If you have clear the ownership, so as I said before, it's in the company and it's not in separated personalities or people, different people owning different rights, and that it's a conglomeration of things. If the agreements are all clear, if you have used NDAs, and what's also, if you have applied for registration of a patent or a design or a trademark, what's the current status? So, wrapping up all that we have discussed today during this webinar, the first and most important tip, and I know that some of you might think, oh, I can do it myself, look for expert advice. There are a lot of initiatives out there right now that are for free, actually. I mean, so, but putting your hands or putting yourself in the hands of somebody that really knows about IP, it's one of the best things that you will do for your own business. Having said that, remember, evaluate your product, your process, your idea before even choosing or considering the type of protection. Think about what are your assets? What is your market? Are you going to stay national? Are you going to go international? Is your market in one that where innovation is running very fast? It's a slow pace innovation. All these kind of business considerations are super important. What's your commercialization plan? You should have one where you're considering your IP. And if you're thinking about going international, then your strategy when it comes to IP needs also to be global. You should always protect or have protected your IP assets in all the countries before entering them, not the other way around, because it's going to be much more expensive if your product or your process or your business plan or your business idea is working to stop others from doing what for misappropriating from your own than the other way around. And when it comes to enforcement, I think it's also very, very important nowadays to consider alternative dispute resolution methods, to consider if the country where you're going, mediation, arbitration are working and where it's that available or not, instead of having to go to court. And having said that, I know it's been probably a lot of information, and the only thing that I can say is that before breathing in, breathing out, and seeking advice, this is a list of different places that can offer you really good advice, starting with the hoster of this webinar for IP Council, but also the IPR Helpdesk Initiative, the European Union Intellectual Property Offices, the European Patent Office, the World Intellectual Property Offices, or national offices around the world, like the UK or the Deutsches Patentamt here in Germany. So go for them. They normally have sections for startups, for SMEs, where they are really, really looking forward with people who are really qualified to give you good advice on what to do with your business idea and how to profit from it using intellectual property rights. Thank you.
Thanks very much, Begoña, for the excellent presentation. And I would like to open now for the time of Q&A. You have there an app which says Q&A, and that's the part where you need to write your comments or questions. I'm not sure if you received the comment that Catherine sent. It's regarding IP Booster, which is a program which is supported by the EU, and they are also providing expert advice. So we will add it after the webinar to our slides. So thanks a lot for pointing it out. Maybe I would like to start with one initial question until we get the others from the list. Begoña, tell us, what are the most important factors that startups should consider when formulating their IP strategy?
Well, thanks for the question, Claudia. I mean, when you're thinking about your IP strategy, I think that it's important to think about long-term goals and long-term product development or process development goals, not just improvising innovations. So it means that any effective IP strategy will become as much about market intelligence as it is about the startup's own evaluation of business strategy, goals, etc. So some important factors are, as I said before, you need to identify what are your business goals, what are the assets that you have, and that might be IP assets, and how to formulate a plan to protect them, and how to, by doing that, you can be accomplishing your business goals.
Thank you. I've received here one question asking whether for SMEs, are there any websites you will advise in particular, in addition to the ones mentioned in the last slide?
Well, I think that for SMEs, both for IP Council, but also in particular IPR Helpdesk have been doing a fantastic work. And IPR Helpdesk, they have, that's an initiative that comes from EASM, the European Commission, and they have different sections. So if you're focusing only in Europe, they also have a special portals for China and from Latin America. So if I would have to go with one nowadays, it will be probably that.
Excellent. And who is the owner of the IPR generated by employees?
Oh, that's also an interesting question. I mean, in the law, it's quite clear. I mean, there is no harmonization or international standard for that. But in most countries, normally, the IPRs that are generated by employees belong to the employer. But that's what I said before, that it's also very important that you make sure that in your employment contracts, you include an IP assignment clause for your employees to make sure that in case in that particular country, the rule that the employer, it's the owner, doesn't apply, that by contract, you're assigning that IP rights to you.
Right, so I see here another question. Why is it important to include our IP in the business plan?
Well, as I said before, I mean, think about the scope of a business plan. The scope of a business plan is to describe not only the business logic behind the commercialization plans, but also the assets and resources that will make the business successful. And IP and IP protection and IP management policy and the business planning exercise are all interconnected. So IP that it's owned by or accessible to the company owners will strongly influence the business model chosen for operating on the market. Also, the business plan normally refers to IP or IP rights that are describing the company's unique specificities and the assets and resources that can be called upon for establishing win-win collaborations or with clients, with partners or investors. Therefore, the comparison of those assets with IPR owned or likely to be acquired by both clients and competitors is to be considered as a key indicator of the commercial viability, no? Whether if it's viable or not, or your business. And it will influence your strategic positioning inside the ecosystem.
Thanks. I have here another 2 questions. So let's go with the next one. Could you please tell us more about how IP should be presented in a business plan? And by the way, we will have a webinar especially on this.
Exactly. So I think that I'm going to leave that for
a good incentive for joining. But yeah, but I think it's very important to make sure you consider these elements on how to present it, because this is one of the issues. I mean, I've been talking last time with one of the inventors and also with this investors, and they were saying they were accepting like 1 each 100 proposals, and very often because they haven't come prepared. So we will definitely go with 3 steps in the next presentation and also in the practical cases.
But if I can say something on that, I mean, going back on the slides, I think that you should concentrate on these 2 parts, strategy and portfolio. This is a way that you can, you know, for starters, you will get much more detail in the next webinar that they are organizing, but I think that's a good starting point. On the one hand, your strategy. So what are you planning on creating, long-term planning always, exploitation, the risk, and especially enforcement, the enforcement risks that need to be considered because there is a lot of money involved there. And then on the other hand, the portfolio. It's very important for investors to see that ownership is clear. So that has been clear up, that we know that the patent application, that it's written there in that business plan belongs to you and not to the university or to a third party or to or that there are three owners in that invention.
So another question, if I pay an inventor to customize his invent, the background, and create a new development, foreground, who is the owner of the foreground, the new development based on the other idea?
Well, I mean, maybe what you need to consider here is that in any patent application, at least under Europe and international standards, you need to include both the owner and the inventor. So if the inventor, I mean, if the inventor needs to be named, needs to be included in the patent, but if the inventor is working for you, I will say that if that has happened, I mean, and then we will need again to go territoriality to where and to the legal framework when it comes to labor law. But I will say in Germany, probably the owner of that new development, that foreground, will be the person who has hired the inventor, if it's a labor relationship, if it's a contractual employment relationship.
Mm-hmm. You may also follow us on Twitter @4IPCouncil. And I would like you to thank you, Begoña, for your time, for sharing with us all these relevant issues. And if participants, if you have any questions, oh, I see you have like one last question. Good. Okay, we have time for one more. Are there any advantages and disadvantages of holding a trade secret?
Okay, well, yes, there are both advantages and disadvantages. I mean, as we said before, there is no registration, so that's an advantage in the sense that there are no registration costs. And the protection is not limited in time, like in the case of patents or trademarks, where, you know, in the case of patent, it's up to 20 years. And the disclosure, like it will be in the case of patents, it's not required. However, the disadvantage is that, well, it might not be the most effective tool when we're thinking about things that are inventions. Because they might be able to be reverse engineered, and when that happens, your secret is out. Then, as we said before, another big disadvantage is that trade secrets are not easily enforceable, and the remedies are also limited. So what you might get, it's eventually a monetary compensation, but your secret will be already out.
Right. So thank you very much again for your time and your expertise. And if anyone else have any comments, questions, please feel free to contact us in 4IP Council. And we're looking forward to the next webinar on the 21st of November. Well, we will get the perspective of a venture capitalist. Thanks, Begoña. Thanks, everybody, for joining.